The topic that I chose for civil liabilities is police pursuits. The video that I put on here is of a Las Vegas police officer in a pursuit in which the subject opened fire on him. So he decided to open fire while in the pursuit, which obviously is a very high liability situation, civil liability. I'm just gonna click off of this. The pursuit is an active attempt by driving an authorized emergency vehicle with emergency equipment activated to apprehend occupants of a moving vehicle if the driver increases vehicle speed, takes evasive actions, or refuses to stop in an apparent attempt to avoid apprehension. And normally in pursuits, it means that once you begin a pursuit, you really don't have a duty to continue. With that, if you decide to terminate the pursuit, it is really unlikely that you'll be held liable for anything that happens if the car continues to drive recklessly. I've added a couple of case laws in my presentation, the first one being the City of Pinellas Park versus Brown. In this case, the officers and deputies from 3 different jurisdictions engaged in a pursuit that involved 15 police cars and spilled into a main roadway. During the pursuit, an unmarked car attempted to enter the main roadway from a side street trying to get ahead of the chase. There was a car parked at the light that he entered the main roadway on. He didn't alert the citizens in the car, and the light turned green. The car took off right in the path of the car that was evading the police. The crash ended up killing the violator as well as the 2 sisters that were inside the car. The problem here is that the officer didn't warn the pedestrians of the danger ahead, but instead was trying to enter the chase. So he did not put citizen safety before the pursuit. The Supreme Court held that the police action in the case created a risk to public that was foreseeable and preventable, meaning that the wreck could have been prevented had the officer been more interested in the safety of the pedestrians and other drivers around the area, at least trying to warn them that there was a pursuit going on. The courts in this case did not prohibit police pursuits, but stated that any police decision to start or continue a pursuit is subject to court review under the doctrine of negligence, not just as use of force under the 4th Amendment. Side notes in this case, the courts also noted that losing a vehicle during a pursuit does not mean police will never find the car or bring its occupants to justice. It is not a matter of catching them now or later, pretty much meaning that eventually the occupants in the car will be caught, whether you decide to continue the pursuit or if you decide to terminate the pursuit. There will still be justice done. Another case that I looked into was Broward versus Inyo County. In this case, the police set up a roadblock. They parked an 18-wheeler on a curve in a roadway and placed a car with its headlights positioned to blind Brower, who was the driver of the evading car. These factors led to Brower crashing his car and led to his death. The Supreme Court in this case addresses the issue of deadly force in police pursuits, such as the video that was shown in the beginning of the presentation. It held that pursuit tactics might result in a claim of constitutional violation as a seizure by deadly force. The courts relied mostly on its earlier ruling in Tennessee versus Garner. The court held that deadly force should not be used to apprehend citizens for minor offenses such as traffic violations. If officers take steps to halt or force the fleeing vehicle to stop, whether it be roadblocks or physical contact with vehicles, the officers are responsible for the results. Pretty much, if police intentionally use their cars in instances such as pit maneuvers where they attempt to nudge the car and try to get it to stop, it becomes a deadly weapon. An agency's use of force policy governs the vehicle's use just as it governs any other weapon of opportunity. The next case is Graham versus O'Connor. This is the U.S. Supreme Court's case regarding use of force. The court made an observation about law enforcement's decision during emergency and pursuit driving. And I think this is a very important one and should be applied to every aspect of law enforcement. The Chief Justice Rehnquist wrote, "Police officers are often forced to make split-second decisions during emergency and pursuit driving circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation." He went on to state that the courts will not second-guess those judgments as long as they are objectively reasonable in light of the totality of circumstances. And that concludes my presentation. Thank you.